Hi, my name is Joe Esquivel and I am with Mortgage Compliance Investigators. Today's video is in regards to an article that I've written, When Should I Invite You to My Quiet Title Party? And looking at the many strategies that are being brought forward that pertain to wrongful foreclosure actions, there are none more disappointing than the quiet title complaints that state a lot of information but that lack substance, form, and timeliness. There is a misnomer in the application of using a quiet title complaint and thinking that the quiet title cause of action is a fix for all problems pertaining to the title of real property that has been clouded by actions of other parties attempting to claim an interest to title. The problem is that in many instances, this is putting the cart in front of the horse. I have viewed many quiet title complaints, and while a lot of claims are made and a lot of facts are stated within these quiet title complaints, it is just sizzle and no viable substance to carry the cause of action. A complaint that pleads facts that are merely consistent with the defendant's liability stops short of the line of possibility and plausibility of entitlement to relief. Quoting Twombly at 550 U.S. at 57. Many times parties are named and claims are stated. However, these claims are not sufficient to support a claim upon which relief can be given. As a result, many of these quiet title complaints are often remanded to the federal courts, where a motion to dismiss is filed by the defendants, and a Rule 12b-6 dismissal is ordered by the courts. Lacking legal sufficiency of claims is being presented is one of the many reasons that these quiet title complaints fail. It is in my opinion that to file a quiet title complaint before a determination of superior right to title has been made is untimely. Unfortunately, that is not what is being done. Many times the parties are named to participate in the quiet title action and then are told that they do not have any standing to respond. A new perspective would be slander of title complaints. Rather than going forth and using a quiet title complaint that enjoins named parties and then attempts to sever the party from the action, first one needs to make a determination as to the culpability of the parties that will be allowed to participate in the arena of judicial litigation. Slander of title is a cause of action that addresses securitization issues and provides a client with the ability to name interested parties in order to clarify if a party has a valid claim to real property supported by statutory requirements of law. A declaratory judgment specific to the parties of a slander of title action would allow the court to declare by statute, example, the defendant is not a party to title of real property that is being disputed. A complaint such as this would set up the status quo for the players who would or not be named in a future complaint that could possibly pertain to clouded title issues created by the securitization of real property mortgage loan instruments. In my opinion, to have the courts make a determination as to the legal rights of a party to any action on the real property, on the title of real property, would come first and foremost. So before any quiet title action, how about an action determine the status quo of the parties with a claimed interest? Thank you.